So, when to get the location. Who needs translation? Can I get some additional I bring one? It's like it's going to get one. So I need get one.
The Pan-African Lawyers Union, and I also chair the steering committee of the International Coalition on the Responsibility to Protect. So I would like to start by welcoming everybody. I was going to thank the African Union for coming, but since the African Union hasn't arrived, we'll thank them when they get here. And then I'm going to thank our partners, the International Coalition, of which we're all members, and especially Stanley Foundation, who together we've put up this event, and which Stanley has facilitated by providing the financing for the meeting. So I'd like to thank you very much. And Keith, the Executive Director of the Stanley Foundation, will be speaking in a minute. So at the end, or at some point in the morning, we will do a round of introductions, so we get to hear everybody's voice early. But just a few remarks. On Article 4H, to note that the African member states were very determined to move from the old OAU policy of non-interference in the affairs of member states to a new policy of non-indifference. And if one were to look over the last 13 or so years, they've been proceeding on a path of gradually but consistently strengthening the normative framework, the implementation framework being the institutions, and implementation. And without preempting what the speakers will say, Article 4H of the Constitutive Act and the Constitutive Act generally should not be viewed in isolation, but they should be viewed in the broader context of the AU. That would include the African peer review mechanism, the African peace and security architecture, and the African governance architecture. So this is what we will be looking at in the course of the day. On responsibility to protect, just to point out that the Secretary General of the UN is very clear that the responsibility to protect has 3 pillars. And pillar 1 says that the primary responsibility of protection falls on the state itself to protect its citizens from mass atrocity crimes. And the second pillar says that the international community has a responsibility to assist states in fulfilling this responsibility. And then the third pillar is the one that says the international community should use appropriate diplomatic, economic, humanitarian, and other peaceful means to protect populations from mass atrocity crimes. But if a state fails to protect its population, or is in fact the perpetrator of the crimes, then the international community must respond in a timely and decisive manner and be prepared to take strong measures, including the collective use of force through the Security Council. So just to highlight that the primary focus of R2P is prevention of mass atrocity crimes. And that we as civil society, and viewing civil society broadly to include NGOs, academics, the media, we play an important role by sounding alarm bells and by calling for action. And that we, especially from the coalition, we view R2P as a vital new tool with which civil society can hold governments and the international community accountable when it is manifestly failing to respond. Later on in the morning, I'll say a few more words about the coalition, but with just these few words to set the base, I would like to welcome my colleague, Keith, to also make some remarks on behalf of the Stanley Foundation.
Thank you very much, Don. Thank you to everyone for being here. As Don mentioned, my name is Keith Porter. I'm the president of the Stanley Foundation. On behalf of the Foundation and the International Coalition for the Responsibility to Protect and the Pan-African Lawyers Union, thank you so much for your participation here today. This is the first continental-wide meeting of the civil society members of the International Coalition for the Responsibility to Protect. As Don mentioned, today's dialogue is to reflect on the implementation of both Article 4H of the Constitutive Act of the African Union and the Responsibility to Protect. It's the first coalition-wide meeting on the continent on the protection of civilians from genocide, war crimes, crimes against humanity, and ethnic cleansing. The 2005 World Summit Outcome document declared the sovereign responsibility of states, which affirmed that states hold the primary responsibility for protecting their populations from those four crimes. In addition, it affirmed that the international community bears a responsibility to assist states in meeting their protection obligations, and that if a state is either unwilling or unable to protect their populations, they have a responsibility to respond in a timely and decisive manner using a broad range of both coercive and non-coercive tools in accordance with the UN Charter. But even before those historic steps were taken by the World Summit Outcome document in 2005, African states had already enshrined the principles echoing the responsibility to protect into law in the year 2000 with the founding document of the AU, which represented a switch from the non-interference approach of the Organization of African Unity to the non-indifference approach of the AU. The AU's Constitutive Act defined the core objective of the Union as the promotion of peace, security, and stability, and the promotion and protection of human and people's rights. It also identified the respect for democratic principles, human rights, the rule of law, and good governance, the respect for the sanctity of human life, and the condemnation and rejection of impunity among its core values. Most importantly, in Article 4H, AU member states embraced the right of the Union to intervene in a member state pursuant to a decision of the Assembly in respect of grave circumstances, namely war crimes, genocide, and crimes against humanity. A major objective of the Stanley Foundation and our collaborators here regarding these dialogues was to seek out voices from the field, men and women who have had to develop innovative ways to work in difficult and oftentimes violent environments. Civil society has a specific responsibility, and that is to give voice to a wide variety of sectors and to enrich and support public participation in democracy. African civil society has been monitoring the varying steps taken by the AU to enhance its capacity to prevent atrocities as a fulfillment of their obligations under the responsibility to protect. In addition, they've been working with the AU to develop and strengthen protection mechanisms, including calling for further measures to be adopted where policies have not yet been undertaken. Today we will hear from African civil society and international organizations working with AU member states and those working at the Pan-African level to share information and experiences on how they are engaging African governments and intergovernmental organizations on the issues of R2P and mass atrocity prevention in general. Today's dialogue comes at a difficult and critically important time as continuing violence in the Central African Republic and South Sudan shape the daily discourse and present a serious challenge to the responsibility to protect as a global norm. Sometimes I hear people say that they reject the responsibility to protect, or that they say that R2P has failed. And when I remind them that the first pillar of R2P, as Don mentioned, says nations have a responsibility to protect their populations, there is no way you can reject that concept. That concept is a sacred part of sovereign responsibility. So the responsibility to protect goes far beyond the conventional wisdom And it gives states an enormous responsibility, and it gives the international community an enormous responsibility to support states primarily in that obligation. We also at the Stanley Foundation have focused primarily on prevention. The idea that there is a lot of work being done on halting genocide, but I think that the good work should be done in preventing genocide long before it happens. Again, on behalf of the Stanley Foundation, the International Coalition for the Responsibility to Protect, and the Pan-African Lawyers Union, I want to thank you very much for being here and participating in this dialogue.
I'm the Executive Director of the West Africa Civil Society Institute, which is a member of the Steering Committee of the International Coalition for the Responsibility to Protect.
Professor Victoria. I also worked as a senior researcher at the Center for Conflict Resolution in Cape Town.
Bonjour, mon nom est Ibrahim Khan. Je suis sénégalais, juriste de profession et je travaille à Open Society Foundation basée à Lyon.
Bonjour, mon nom est Francis Daco. Je suis le coordonnateur Afrique de la Coalition pour la diplomatie internationale. Je suis basé à Cotonou.
Good morning, my name is Angela Bruce Rayburn, and many of you probably already know me from all the emails you got from me in the last 2 weeks. So I work for the Stanley Foundation, I'm the program officer, and I oversee the program for human protection. Thank you.
Hello, I'm Tilly Gallis. I'm the Executive Director of the Atrocities Institute, and our regional programs work in Latin America and in Africa.
Hello, my name is Victor Chen. I'm from Uganda. I work for African Youth Initiatives Network. We do work in northern Uganda, but we are seriously started working in South Uganda, targeting specifically how to employ the multiple role young people play in right now.
Good morning, I'm Suleiman Janati from Sierra Leone. I'm the Executive Secretary for Coalition for Justice and Accountability for Cambodia. We have been working with one of our transitional justice mechanisms in Sierra Leone called Special Court, working with victims and also trying to see that the right of the perpetrators were protected.
Good morning, my name is James Gondi. I'm from Kenya. I work for an organization called Information. I'm a deputy director and head of programs there. Information documents human rights violations in Kenya in the areas of justice, inequality, corruption, and other forms of marginalization in Kenya, and tries to broadcast that to the world using audiovisual means and using information technology.
Thank you. My name is Frank Kamunga. I'm a Stanford Fellow on Democracy, Development and Rule of Law. But actually, I work as the Executive Director of Droits Humains Sans Frontières. It's human rights network is one of the society organizations working for human rights, peace, and democracy in DRC, and I'm a member of the National Coalition for the Responsibility to Protect. Thank you.
I'm a research fellow with the Kofi Annan Peacekeeping Training Center in Accra, Ghana. The Kofi Annan Peacekeeping Training Center works broadly in conflict prevention, peace support operations, and post-conflict reconstruction. Thank you.
Good morning, everybody. My name is Gerald Bayubai. I'm the Executive Director of Youth Action for Development, which aims at promoting social and economic rights of young people, and we intend to prevent them from returning to group arms or militias in the Great Lakes region, especially in 3 countries, Burundi, Rwanda, and DRC Congo. But we are based in Bujumbura. Thank you very much.
Good morning. My name is Shivai Nyoni, and I'm with the Center for the Study of Violence and Reconciliation based in Johannesburg in South Africa. I am the advocacy lead of the organization. The center focuses on issues of conflict transformation, peace building, as well as transitional justice.
My name is George Kigoro. I'm the Executive Director of the Kenyan section of the International Commission of Jurists. We are based in Nairobi. and we work on, among other issues, international justice in Kenya, but also around the Eastern African sub-region. Thank you.
Good morning, my name is Stephen Kirimi. I also come from Kenya, and I'm the Chief Executive Officer of Peace and Development Network, which is a national organization supporting mostly local level organizations, or what some people may want to call grassroots, on programs for peace building, conflict prevention, and security.
Good morning, everybody. I'm Philip Masabo from Bujumbura, working with the Center for Training and Development of Ex-Combatants. We are working with youth ex-combatants and working also in assistance of women victims of war in Burundi. Thanks.
Good morning. My name is Muhammad Badawi, works for Africa Center for Justice and Peace Studies, based in Kampala. Our focus is Sudan and South Sudan. My organization, one of the organizations, was in 2009 following the indictment of al-Bashir, and now we are working for conflict.
Thank you. I'm Sisa Walumbe. I'm the Secretary General of United Nations Association of DRC, and a member of RTP coalition in my country. We work mainly on conflict and mass atrocity prevention. We work on civilian protections, and we work, of course, on human rights promotion. But mostly we do try to engage United Nations mission peacekeeping operation in Congo, and also government, to listen to the voice of the community and to integrate their proposal into mechanism of prevention and protection.
My name is Victor Misi. I'm Executive Director of Intergovernmental International. We are based in Canada. We are working with youth and to promote development and to prevent violence in Great Lakes.
Good morning, my name is Desiree Sabavi. I'm the head of Oxfam Liaison Office with the African Union. Oxfam operates in 35 countries in Africa, but in terms of conflict and humanitarian intervention, we focus now on 5 countries: Sudan, South Sudan, Mali, DRC, and Somalia. We basically do policy advocacy, but also humanitarian intervention, and allowing citizen participation in the African Union.
Thank you all very much for the introductions. And
Good morning, everyone. My name is Ayero Getachew. I'm from Ethiopia. I'm a legal researcher at the Committee of Experts on the Rights and Welfare of the Child at the African Union. Thank you.
Good morning, everybody. My name is Angela Mabukati. I'm from the Southern Africa Litigation Center. We're an organization that specializes in human rights and rule of law issues, and I'm in charge of the International Criminal Justice Program.
Good morning, everyone. My name is Stephen Lamoni. Some people prefer to call me Steve Lamoni. I work with the Coalition for the International Criminal Court, and I'm responsible for the African Union, United Nations, and all the ICC situation countries, and I'm based in New York.
Good morning, everyone. My name is Johnston Okech. I work with the United Nations Office for the Coordination of Humanitarian Affairs, Liaison Office to the African Union.
Good morning, I'm Stella Ndirango. I work with the Kenyan section of the International Commission of Jurists, heading a program that works on international criminal justice.
Good morning, everyone. My name is Megan Schmidt, and I work with the International Coalition for RTP, based at our Secretariat in New York.
Good morning. My name is Wende Gabriel-Selassie, and I am from the Ethiopian Lawyers Association, and we are based in Addis Ababa.
Good morning. My name is Sue Moore. I'm representing the Australian Government. I'm the head of the Australian Government Aid Program based here in Addis.
My name is Nkunda, and yeah.
Adela Duskilangi. I'm a member and currently the president of the African Union Commission on International Law.
My name is Madeline Schwartz. I'm the Human Rights Judicial Officer with the Mary Robinson, the Office of the Special Envoy for the Great Lakes region.
Skepticism. And there's a fear that it's just another window for imperialists to take over Africa. Now, it's interesting that this is the case, especially since if you look at the historical trajectory of what we went through before we got to Article 4H, right from the Conference on Security, Stability and Development and Cooperation in Africa in 1991, coming out with the Kampala document, which actually redefined sovereignty, looking at sovereignty as responsibility, rather than just protecting territorial integrity and sovereignty. Following that, looking at how African governments, through the Ezowini consensus, even endorsed an imagined R2P norm way before 2005. And looking at the kind of work that the African Union itself, by the time it got to 2002, when it metamorphosed from OAU to the AU, having Article 4H and even the frameworks that it puts together, one questions why we still have that kind of skepticism and doubt. But again, you can somehow understand, because one also questions the capacity of the AU. Political will, there are concerns around that, the lack of political will. There are concerns about whether the AU is not too heavily donor dependent. There are concerns about the military and looking at how the AU can even equip the military and give it the logistical support that it needs. And we are looking at these issues, talking about what happened, looking at what happened in Libya and what's happening in CAR now, and in our concerns with South Sudan. So I think that this is a good time for us to discuss this and reflecting on 20 years of what happened in Rwanda. This is a really good time to talk about this. And we've got an excellent panel that will be looking at the AU itself, the normative framework and the different institutions that it has put together, as well as civil society's engagement with the AU. So our speakers have 10 minutes each. We have 4 speakers, we have 3 now, we'll have 1 joining us soon. They have 10 minutes each to speak to their topics, and then we'll have space for us to engage because there's a lot of knowledge also in this room and experience. So I'd like to invite our first speaker, who is Mr. Charles Mora. Did I pronounce your surname correctly? I hope so. He's the expert, Continental Early Warning System and Preventive Diplomacy with the African Union Commission. Mr. Mora, you have
do I use the microphone or? The transition to the AU is most markedly seen in terms of the enshrining of the principle of non-indifference. And therefore, Article 4H begins or becomes the entry point at which the AU begins to address the failures of conflict prevention, management, and resolution in Africa, as witnessed by the Rwanda genocide and many other cases in Africa. And therefore, Article 4H gives rise to the debate on what should Africa do in terms of the implementation of that, and in terms of how do you begin to apply the principle of non-indifference. And what comes up is the discussion and eventual adoption of the protocol relating to the establishment of the Peace and Security Council of the African Union. And enshrined in that protocol is first and foremost the right of the AU to intervene in certain conditions, particularly grave circumstances. And secondly, the right of AU member states to call upon the AU or member states of the AU to intervene when a country is facing grave circumstances. That could not have been done under the OAU, even if Rwanda had requested intervention. the OAU did not have an instrument that would have allowed it to intervene. And therefore, most of our activities in terms of the AU's responsibility on prevention and response is what is enshrined in the protocol relating to the establishment of the Peace and Security Council. There are also other instruments that call upon the AU to have a role in conflict prevention. And here one can mention the AU strategy on mediation, the Continental Structural Conflict Prevention Framework, the Post-Conflict Reconstruction and Development Policy of the AU, and the AU's border program, and the Declaration on Cooperation in Borders. And we usually divide these two into structural and direct prevention. If you're going to do direct prevention, you're going to undertake things like good offices under the offices of the chairperson, you're going to undertake mediation, you're going to undertake initiatives on early warning. If you're going to do structural prevention, you would want to address certain structural issues that do cause conflict, although they change very slowly over time. And perhaps the foremost initiative that the AU has taken on this is the initiative on borders, from barriers to bridges of cooperation. How do you, as integrating African units, build borders as bridges of cooperation and further integration, rather than them being barriers to the movement of labor and capital? Also worthy of mention here would be the African Charter on Democracy, Elections and Governance, which does put obligation on AU member states in terms of what they should do in protecting human rights and also in preventing conflict, which can lead to grave circumstances. But perhaps before I end, let me look at the institutions that constitute what we call APSA. First and foremost is the Peace and Security Council, which is composed of 15 member states, 10 elected on a 2-year term, 5 elected on a 3-year term. And it has the primary responsibility in Africa for peace, security, and stability. To support the activities of the Peace and Security Council, they created a panel of 5 eminent African personalities from the 5 African regions. And that panel is given certain autonomy in terms of its ability to pronounce itself on any situation that is of concern on the African continent. It also does exercise a function in terms of mediation and good offices. And it has created what is now being referred to as PAN-WISE, which is an Africa-wide panel of the WISE, which brings together the panel of the African Union and similar organs of the regional economic communities. There is the Continental Early Warning System, and the Continental Early Warning System is supposed to mark the shift from the focus on state security to human security. We are supposed to use open sources in terms of trying to anticipate the likelihood of conflicts in Africa. And then, of course, there is the African Standby Force and its rapid deployment capability that has recently been created, and the initiatives in terms of operationalizing these institutions. The AU sees a timeline of 2015, but having adopted the protocol in July 2002, and the protocol being ratified in December 2003, there were already existing conflicts that required the attention of the African Union. So operationalization has gone hand in hand with operational engagement in certain areas of conflict prevention. And I think I will stop there, Chair.
Okay. You have these frameworks that he has just told us.
Merci, Madame. Madame, je remercie beaucoup les organisateurs
pour l'opportunité qu'il nous offre de pouvoir débattre un peu de ce problème que vous avez évoqué dans votre introduction, la responsabilité de protéger. On dit que la responsabilité de protéger incombe aux États, incombe aux organisations régionales et incombe, si on peut dire, à la communauté internationale. Mais vous-même, vous l'avez dit, que dans le contexte africain, la responsabilité de protéger peut être assimilée à une responsabilité des autres de nous protéger. Tellement le contexte africain est un contexte où on a assisté à des situations où les États africains, les institutions africaines sont pour vous donner quelques éléments d'illustration. Pensez-vous que les 5 millions de Congolais qui ont péri pendant les 7 années de conflit que le Congo a connu et continue de connaître, pense à la responsabilité de protéger du Congo ou des États africains? Pensez-vous que les 1000 et quelques Guinéens qui sont tombés un 28 septembre à Conakry, simplement parce qu'ils demandaient à ce que les élections soient organisées, ont obtenu ce droit d'être protégés? Pensez-vous que les milliers d'Ivoiriens qui sont morts pendant toutes ces années ont eu ce droit, l'exercice de ce droit? Tout simplement, cela n'a pas été possible parce qu'on est sur un continent où on n'a pas les moyens de nous. Le cadre juridique, je ne peux pas dire qu'il est parfait, mais c'est un cadre juridique qui permet une protection minimale des droits de la personne humaine. Vous avez l'acte constitutif, on a parlé de ce fameux article 4H, mais on oublie que ce fameux article 4H a été précédé par l'article 58 de la Charte africaine des droits de l'homme et des peuples, dans lequel il était dit que si, dans des situations de violation grave et massive des droits de l'homme, la Commission africaine devait demander à la conférence des chefs d'État de prendre un certain nombre d'initiatives. La Charte africaine des droits de l'homme est entrée en vigueur en 1986 et l'année dernière, on célébrait les 25 ans de la Charte africaine des droits de l'homme à Yamoussoukro. Et le constat a été que cette disposition n'a jamais été appliquée par les États africains, malgré les tentatives des commissaires africains de faire intervenir, notamment dans les situations du Burundi, quand il y a eu le conflit dans les années 90, au Zimbabwe, dans le Matabeleland, je peux continuer à citer le nom, mais ça n'a pas marché. On a créé ce nouveau mécanisme et on oublie que ce nouveau mécanisme, quand on lit de manière très rapprochée, aussi bien l'acte constitutif que le protocole sur le Conseil de paix et de sécurité, c'est qu'il y a un conflit latent entre le concept de souveraineté qui est mis en exergue et qui est même mis avant les dispositions relatives à la responsabilité de protéger et la responsabilité de protéger. Donc, c'est un point. Et en droit, vous savez, quand on dispose les normes d'une certaine manière, ça a une certaine signification. Je voulais juste mettre cela en exergue parce que je reviendrai là-dessus. Les États africains sont allés même plus loin parce qu'ils ont mis en place un Conseil de paix et de sécurité dont deux dispositions fondamentales, les articles 3 et les articles 4, sur les objectifs et sur les principes de fonctionnement sont très clairs et qui mettent aussi en exergue cette tension entre la souveraineté et la responsabilité de protéger. Mais vous avez aussi dans ce texte une confusion entre les rôles. Et je suis bien heureux qu'un responsable de l'Union africaine soit ici. C'est entre les rôles et responsabilités du Conseil de paix et de sécurité en tant que tel et du président ou maintenant de la présidente de la Commission. Dans l'article 7, on dit, parlant des pouvoirs du Conseil de paix, on dit conjointement avec le président de la Commission, le Conseil de paix Et on va en l'article 10, on dit que le président de la commission, sous l'autorité du Conseil de paix et de sécurité, assume un certain nombre de responsabilités. Et on a vu dans la pratique, notamment quand il y a eu les événements de l'Afrique du Nord, que l'inaction de l'un et de l'autre a créé une situation pendant laquelle, pendant une vingtaine de jours, on ne savait pas quelle était l'attitude du continent vis-à-vis de la situation en Tunisie, où on avait tué beaucoup de personnes, vis-à-vis de la situation en Libye et dans une moindre mesure vis-à-vis de la situation en Égypte. Et donc, pour dire que le cadre juridique aussi mérite qu'on y prête une certaine attention parce qu'il n'est pas aussi clair en termes d'intervention. Un troisième point que je voudrais souligner et qui de mon point de vue, explique le contexte dans lequel on se trouve, même actuellement, c'est que les niveaux de pouvoir étant un peu disparates, vous avez un Conseil de paix et de sécurité, vous avez une présidente de la commission et on oublie aussi le président en exercice de l'Union, qui ont chacun une certaine autorité et qui, quand il s'agit maintenant de décider de l'intervention, parce que n'oubliez pas que l'article 4 ne parle pas de l'intervention, parle d'un droit de l'Union africaine d'intervenir. Or, tous les problèmes qu'on a connus jusqu'à présent, c'est le problème de l'intervention elle-même. Parce que dans la plupart des cas, citez-moi vraiment un exemple où il y a eu une intervention effective par rapport à une situation. Le Mali, on a tergiversé et finalement, c'est les étrangers qui sont venus à leur place. En Centrafrique, on a tergiversé, c'est les Européens qui sont venus encore à notre place. Au Sud-Soudan, on est encore en train de tergiverser, les gens sont en train de s'entretuer et jusqu'à présent, il n'y a pas une intervention effective. Et on peut suivre, pour moi, vraiment l'image qui est à la fois tragique, mais à la fois aussi qui démontre la faiblesse du continent, l'incapacité du continent. Pour moi, c'est la République démocratique. Et jusqu'à présent, jusqu'au moment où je vous parle, on n'est pas encore arrivé au bout du rouleau. Et donc, la question que je me pose, à quoi ça sert d'avoir des normes quand une organisation est incapable de mettre en œuvre ses propres normes? C'est là où je pose un autre problème. Parce que, au fond, le problème n'est pas le manque, le souci des responsables de l'Union africaine. Je suis persuadé que Mme Zuma, les différents présidents mensuels du Conseil de paix et de sécurité ont tous à cœur d'intervenir pour que le continent n'ait pas cette image. Mais le continent n'a pas les moyens de sa politique. Pour intervenir dans une situation particulière, ça requiert à la fois des moyens humains, des moyens matériels, comme vous avez souligné, madame, même si certains de nos États l'ont. Mais au plan continental, on n'est pas encore en mesure de mutualiser nos efforts pour arriver à une situation où on intervient. Tout à l'heure, le représentant de l'Union africaine a parlé de l'architecture africaine de la paix et de la sécurité. On a même une force africaine en attente. Mais cette force africaine en attente, d'abord, elle est virtuelle. Elle n'existe pas. Mais même si elle existait, même si les États décidaient de mettre en place, parce qu'en Afrique de l'Ouest, on a eu cette expérience, de transporter les troupes, ça devient un problème. Et donc, au fond, si on doit arriver un jour en Afrique à matérialiser la responsabilité de protéger, en tout cas, pas de la part des États, mais de l'Union africaine, mettre en œuvre ces dispositions, l'Afrique doit avoir les moyens. C'est ça le problème. Ce sommet, dimanche, samedi et dimanche, les ministres des Affaires étrangères vont se réunir dans une ville hors d'Addis Abeba. discuter des finances de l'Union africaine. Et je pense que cela est au cœur, de mon point de vue, d'une des solutions à la résolution. Parce que si on ne met pas en place ces moyens, à la fois matériels, humains, si on ne mutualise pas les efforts, les moyens en Afrique, regardez un pays comme l'Algérie, un pays comme l'Afrique du Sud, dans une moindre mesure un pays comme l'Égypte, qui au lieu d'utiliser ses moyens contre sa propre population, aurait pu utiliser ses moyens pour empêcher les violences en Centrafrique. On aurait pu mutualiser les efforts de manière. L'Afrique du Sud a montré l'exemple dans la République du Burundi, où l'Afrique du Sud payait par jour $1 million pour arriver à la paix. Aujourd'hui, on est tous en train de célébrer au Burundi. Et donc, vous voyez que si les efforts sont bons, si comment dirais-je encore, la volonté politique existe, on peut arriver à des solutions. Mais est-on en mesure, ou a-t-on la volonté de donner à l'Union africaine les moyens de sa politique? C'est ça. Et j'aimerais terminer par une image, parce que vous savez, quand on fait ce genre de débat, c'est toujours bon de garder une image. Pour le ressortissant ouest-africain que je suis et le foulard que je suis, si je devais vous comparer aujourd'hui l'Union africaine à un danseur, j'aurais dit que ce serait un danseur de Yéla. Le Yéla, c'est une danse où on fait un pas en avant, 2 pas en arrière, on passe à droite, on passe à gauche, on tourne autour de soi-même et ensuite on regarde l'auditoire. J'ai l'impression que nous vivons cette réalité. Et donc on doit changer non seulement le ton de la musique, on doit changer la façon de danser pour qu'on puisse vraiment faire en sorte que les Africains puissent être protégés par l'Afrique. Merci.
And you raised some very, very interesting points that I'm sure all of us
look at the available institutional mechanisms for undertaking and discharging responsibilities relating to the responsibility to protect. To start off, I think it would be fair to say that, as you all know, before the idea of the responsibility to protect was conceptualized and institutionalized into the global peace and security architecture during the 2005 World Summit. The African Union, in its Constitutive Act, reflected at Article 4H of the Constitutive Act a principle that gave the Union, for the very first time, the right to intervene in a member state with respect to specifically identified cases. And this was a major departure from the diplomatic practice and normative framework of the AU's predecessor, the Organization of African Unity. And in that context, building on earlier discussions relating to, within the framework of the UN Charter, 2 of the major principles that were incorporated in the Charter have to do with, first, principles having to do with the protection of the interest of states, and therefore principles like non-intervention and the sovereignty of state. On the other hand, we also have human-centered principles, particularly relating to human rights, having been reflected in the UN Charter. And now, for a very long time, there was no clarity on how to go about resolving the tension or rivalry between these two. And for, of course, during the Cold War, it was the state-centered principles of sovereignty and non-intervention that prevailed over the protection of human rights. And given the incidents that we witnessed, particularly here in Africa, it was in a way no surprise that for the African Union as well, that issue should have been resolved in such a way that in identified specific cases, preference should be given to human rights over the principle of non-intervention and state sovereignty. And therefore, under Article 4H, that is a clear case where we see state-centered principles of sovereignty and non-intervention can be suspended in favor of protection of human rights. And this is where actually the link comes with the responsibility to protect. Of course, under Article 4H, you have 3 cases: genocide, war crimes, crimes against humanity, and R2P includes ethnic cleansing, right, as an additional base. And R2P have been articulated under the International Commission on State Sovereignty and subsequently under the 2005 World Report. It includes quite a very comprehensive implementation modalities, if you like, including prevention and then response and then rebuilding. And in all that, the responsibility of different actors having been taken into account. And as with responsibility to protect, there has to be a multilateral approach to the implementation of the responsibility to protect. And so is the case with respect to Article 4H of the African Union Constitutive Act. But unlike the responsibility to protect, which provides for the expansive and comprehensive modalities of implementation, under Article 4H is basically a 2-line principle. And the question of its actual operationalization and implementation is not articulated at the time that the principle was incorporated into the Constitutive Act of the African Union. The only thing that we know of within the framework of the Constitutive Act was the fact that the responsibility for invoking Article 4H was assigned to the Assembly of the African Union. So it is the Assembly of the African Union as the highest decision-making body that would, ask the question of whether or not we have a situation in a particular case that reveals a threat or actual occurrence of any of the grounds: genocide, war crimes, crimes against humanity. And then after deciding that, then it is the Assembly that would then decide on intervention. Okay, the intervention may take, of course, different forms. Since 2000, of course, since the adoption of the Constitutive Act, another important milestone was the adoption of the protocol establishing the Peace and Security Council of the African Union, which provides for a comprehensive mechanism for pursuing peace and security on the continent by the African Union. That is where the different institutional makeups for the implementation of Article 4H of the Constitutive Act, and hence by implication R2P would come in. And there you find a number of institutions having and assigned the role of playing different responsibilities. It starts, of course, with the continental early warning system. And with respect to the continental early warning system, of course, some of the questions that you raised with respect to the implementation of Article 4H is the question of whether or not the issues that are highlighted under Article 4H are adequately captured in the different indicators and modules developed by the continental early warning system, so that those items specifically can be separately captured, and therefore the necessary follow-up mechanisms are triggered from the level of the continental early warning system, which is based at the level of the African Commission, and it is supposed to work in such a way that it is networked with the early warning mechanisms of what the Peace and Security Council protocol calls regional mechanisms on conflict prevention, management, and resolution, which are basically the conflict prevention, management, and resolution mechanisms of the regional communities, such as SADC, ECOWAS, IGAD, and the others, ECAS, those like those ones. Of course, at that level, one of the issues that you would have is the question of whether or not the different, that is, the regional early warning systems and the early warning system, the continental system, there would be a coherence in their assessment of the particular situation between the two levels. That is, in a way, also a political question in some ways, not just a technical question, because it is after all the technical processes and the analysis having been done that a determination needs to be made by human beings on whether or not we have a situation of the kind that is specified under Article 4H. Now, apart from, of course, the continental early warning system, you have the Peace and Security Council. The Peace and Security Council, being the highest decision-making on matters of peace and security, comparable to the UN Security Council, is the one that first actually decides on whether or not Article 4H should be invoked and therefore applied in a particular situation. It is upon the recommendation of the Peace and Security Council that the Assembly finally decides and acts upon the implementation of Article 4H of the Constitutive Act. Now, in all of these, one of the things that you see particularly from the work of the Peace and Security Council is that a range of tools and instruments are deployed from the side of the Peace and Security Council, which also include, among others, for example, requesting the African Commission on Human and People's Rights to undertake an inquiry into a particular situation. For example, this was done with respect to Darfur. That was the first major case that you remember as far as the possible application and invocation of Article 4H was concerned. And the African Commission on Human and People's Rights indeed undertook a visit, and it prepared a report on the situation in Darfur. In between, however, subsequent to that, the AU institutionalized another institution, which is the AU High-Level Panel on Sudan, which developed a comprehensive report on how to go about addressing issues of justice and peace in the context of Sudan. One of the things that you find in the work of the Peace and Security Council, as far as Article 4H is concerned, the obvious position is that there was no time at which the African Union expressly invoked Article 4H. So Article 4H essentially seems to have remained an article that has no operational reality to date. The question that you ask is whether or not we haven't witnessed during the existence of the Peace and Security Council since 2004 situations that warrant the invocation of Article 4H of the Constitutive Act. My reading of the work of the Peace and Security Council is that, yes, expressly Article 4H was not invoked. The only time that it was invoked was in one session of the Peace and Security Council dealing with Darfur. And even then, there was only one line which said that the situation in Darfur doesn't constitute genocide. Now ask yourself, on what basis did the Peace and Security Council arrive at such a conclusion? Was an investigation undertaken, and so on and so forth. So that is one thing. And how are other cases, which is how was war crimes, how are crimes against humanity? Didn't those take place in Darfur? And if they did, why didn't we say anything about it? My reading is this one. The African Union seems to recognize its limitations. If it invokes Article 4H, then it means that a number of consequences would follow. That may make the position of the African Union extremely difficult, and whatever leverage that it may have in influencing, the situation on the ground would be lost in the process. So the approach that the African Union took was it avoided the express invocation of Article 4H, but acted in such a way that it would be able to come to the rescue of those affected communities. That's what it did in the case of Darfur, basically, against a government that was intransigent, that was resistant of any international or foreign intervention in the country. Thank you very much.
Thank you very much.
I'll build on excellent prayer that these thresholds for intervention are not as straightforward as they seem. For instance, how do you determine that they are war crimes? You need to have an armed conflict, internal or international. But then we all are aware of the problems of war crimes because it's usually the vanquished who are being accused of committing war crimes. And also you recall what happened in Rwanda. A lot of time was spent on determining whether or not genocide was occurring in Rwanda. Therefore, it is difficult to determine when or not genocide has occurred. And we are also aware that we don't have a specific treaty for crimes against humanity. In short, you need those violations of human rights to be widespread and systematic. So in short, it's not as straightforward as the threshold seem to be stipulated by the Article 4H. And then we also have a problem of authorization, the debate as to who authorizes the use of force in international law, particularly from the point of view of Article 4H, has not been settled. My colleague Solomon has said that it is the African Union Assembly that decides to intervene. But we're all aware that to use force in international law, you need the sanction of the Security Council. And we also, I think Nana mentioned the issue of political will. How do we raise funds? How do we mobilize troops to intervene? So all those questions have not been addressed, as Ibrahima lamented. And there is also a focus of thinking of the right to intervene as the use of force. But if you look at the thresholds for intervention, war crimes, crimes against humanity, and genocide, these are serious crimes in international law, which are subject to universal jurisdiction. And yet, the International Criminal Court has not been brought into the conversation of the intervention under Article 4H of the African Union Constitutive Act. But also, if you look, like my colleague Charles indicated, if you draw the picture of the African peace and security architecture, the African human rights mechanisms are not part of the African peace and security architecture, and yet the thresholds for intervention are actually fundamental violations of human rights. This brings me to the question of prevention. How do you prevent these mass atrocities? So we need to bring in the African human rights system in order to avoid intervention, which in my view implies the use of force. And I also want to draw parallels between Article 4H and the responsibility to protect. But to do that, I need to bring you back to 2001, when the International Commission of Intervention and State Sovereignty coined the notion of the responsibility to protect. And you may also agree with me that the understanding of the International Commission of Intervention and State Sovereignty and the responsibility to protect as adopted by the World Summit outcome are not necessarily the same. The ICISS looked at the responsibility to protect as having three pillars, or namely the responsibility to prevent, the responsibility to react, and the responsibility to rebuild. But all these notions have now been left out in the World Summit outcome, where we're focusing on the three pillars as enunciated by Ban Ki-moon, namely the responsibility for the state to protect its citizens or populations, and the responsibility of the international community to assist the state or the target state in preventing mass atrocities And then the final one, which is the responsibility of the international community to act decisively and in a timely manner to protect populations at risk. Now, I think I need to bring to your attention that my understanding of Article 4H is equal to the third pillar of the R2P principle, meaning Article 4H, in my view, entails the use of military force. I'm saying this because if you look at the Constitutive Act, there are other peaceful or non-coercive mechanisms to intervene. So when Article 4H was being drafted, in my view, the drafters entailed the use of military force to protect populations from those three serious international crimes. And I also just want to bring to your attention what we have done as regards bringing clarity to these issues, especially Article 4H and the responsibility to protect. We had a conference in December 2012 whereby we came up with a document that we call the Pretoria Principles. The idea of the Pretoria Principles was basically to bring clarity to these issues, because they are not as straightforward as they've been written in Article 4H. So we basically defined our common understanding of Article 4H, and we also suggested how Article 4H should be implemented by the African Union, and also drew parallels between Article 4H and the responsibility to protect. And we also came up with, just published a book that was published actually by Routledge, and it was released in November. Fortunately, there are two brothers here, my brothers Solomon and Frank, contributed rich chapters to that book. And I also took part in drawing what we call a doctrine of mass atrocity response with the Carr Center at Harvard University, whereby we looked at how the military can use force to protect populations at risk. And in September this year, we plan to have a conference where we want to bridge the gap between Article 4H, the responsibility to protect, and the protection of civilians on the ground. I will entertain questions later, but I think that's all for now.
Thank you very much. I think that you've all raised some key issues that will be interesting to discuss now. We've had